Hi, I'm attorney Chris Reich, and in this video I'm going to discuss whether you can expunge or set aside an excessive speed conviction. So first, that word expunge, it means to erase or remove completely. In Arizona, it's simply not possible to expunge a criminal conviction. You cannot completely erase it from your record or make it so that it never existed. Arizona does have a provision, though, that most criminal convictions you can apply to the court where you're convicted and ask them to set aside the conviction. And so what that means is if the court grants that application and sets aside that conviction, it undoes the finding of guilt for that charge, and it also then dismisses the charge. So this is kind of, call it like a legal fiction. So basically the court's going back in time, undoing the conviction and dismissing the charge. And so functionally, what does it mean if you get a charge set aside? Even if you get a conviction set aside, it's not going to change any motor vehicle division consequences that you had. That record's still going to be there. Any consequences there are still going to be in effect. It's not going to erase the existence of the court case. Somebody could still go online and see this court case existed. As far as criminal background records, that is what it changes. So in Arizona, the Arizona Department of Public Safety, the Highway Patrol, that's who maintains criminal background records. And so if you have your conviction set aside and somebody goes and does a criminal background check on you, that charge is still going to show up on that record, but the disposition, the outcome is going to be different. It's going to reflect as having been set aside rather than a conviction. It's also going to change how you might answer a question on a job application, for instance. You might see a question, have you ever been convicted of? And assuming the only conviction you ever had is that one you had set aside, at that point you could answer no, because that conviction has been undone. And a note about convictions, I'm not talking about convictions for the purpose of immigration. Immigration law has a totally different understanding of what a conviction means, so this does not really apply to that situation. The frustrating part here is that most criminal moving violations have been carved out of this set-aside provision, as in the courts don't have the legal authority to set aside many criminal driving convictions. So this is going to include things like excessive speed or aggressive driving or racing or exhibition of speed. If you're convicted of one of those criminal driving charges, the court doesn't have the authority to set them aside. You can make that application to the court, and some courts will grant that application ordering that it be set aside, but then you may run into problems with how the Department of Public Safety handles that. If the court didn't technically have the authority to set it aside, there's a good chance that the Department of Public Safety is not going to update your record to show that it was set aside. That sounds like bad news, and it is quite frustrating, but I'm making this video in April of 2020. There is pending legislation in Arizona. It's House Bill 2412. This would change that set-aside law and open it up to criminal traffic violations. So if this bill passes, and we think there's a good chance that it will, you could apply to the court to have your excessive speed or racing or whatever set aside, and the court would have the legal authority to grant it. And if they did grant it, then Department of Public Safety would be required to update your criminal history and show that it was set aside. So hopefully in a couple months, we will be processing a whole lot of applications to set aside excessive speed convictions.